Welcome to another edition of the Advisor's Guide to Estate Planning, where today we're going to break away from interviewing a financial advisor, and instead we're going to have a conversation with Encore's partner law firm for the state of Texas, Ross&Matthews. Ross&Matthews was founded in 1990. They're based in Fort Worth. They're a team of actually 100 attorneys specializing in many areas of law, but they have a robust estate planning team. And so today we're going to chat with one of the partners, John Saltarelli. John is a partner at Ross&Matthews, and not to age him or anything, but he was one of the first attorneys hired back in 1990. And so welcome, John, to the Advisor's Guide to Estate Planning podcast.
Hey, Matt, great to be here. Thank you for having me.
Yeah, we're thrilled to be able to do this in a new podcast in a new way and have this conversation and hear more about estate planning in Texas specifically. And so, could you share just kind of for context a little bit more of the background of Ross&Matthews and details related, kind of just your firm and what you guys are about?
Sure, you bet. Yeah, like you said, we're based in Fort Worth, Texas, and the firm was founded in 1990, and I've been with the firm since 1990. And we do practice in all areas of law. Through our relationship with one particular client, we also, as part of that practice, have a very robust estate planning department. We probably do on the average of about 500 wills per month. And that's my own background as well. Estate planning and probate is what I have practiced for the most part of my career.
In Texas all those years.
Absolutely, yes.
Well,
Yes.
cool. For Encore, it's still fairly new that we have this state-specific attorney review option. And some of our advisors really even aren't aware of how that works and that it's available in Texas. And so hopefully we're bringing some awareness to that today. So thanks for jumping on this conversation with us. So out of the gate, I thought we could explain kind of how that works. And as advisors may not be aware of it. And so one of the things is what happens is at checkout, if you were to do a Texas-based estate plan in Encore, you will see the option on that checkout to do a what we call state-specific attorney review of the documents, and there is a letter that Ross&Matthews puts together, reviews the documents. I'll have John talk about that. That's available as an option, as a secondary review to the Encore team. And there's also the option to choose to do a phone call as well for the client with one of the attorneys on John's team. And so that can be chosen at checkout. What happens is the normal human review that Encore does takes place when that gets submitted to us. And we do our 60-point checklist of that quality control, that first level of review. But when this option is chosen, we normally turn documents around in 5 business days. We have a little bit longer turnaround time. And when our team is complete, we actually, within our software, throw it over to John's team and they get a notification and then they log in and they're able to see the documents that have been created with all the decisions in the software, our review, and then also they can see all of the inputs in the software. So they can see everything related to that client. And that's where you jump in, John. And so I'd love to share kind of as you review those inputs, what are the things you're looking at as well as you create the review letter that goes back to the client?
Sure. So the first thing that we're looking at, of course, is the questionnaire that the client filled out. We want to know all about the client and their family situation, their assets, their desires, how they want their estate to be handled going forward. So we review all of the information input to be sure that we understand exactly what the client is looking for. And then we review the documents, whether it's the trust document and the related funding documents, or whether it's a will. And we will look at that to be sure that it is consistent with the questionnaire and what the client is wanting as the end product. So then we produce the letter at the end, which simply confirms that the documents are in compliance with Texas law and they do match what the client is requesting.
And then also you kind of will give a little bit of the insights to is from the funding aspects as well, usually within that letter. Maybe speak to that a little bit, the
Yes. So, the main thing is real estate. A lot of issues that we've had over the years is when a client wants a revocable living trust, they are somewhat slow in following through and getting that trust funded. Because if you create the trust document, that doesn't do you much good unless it's funded. So our letter speaks to that in quite a detailed fashion. Now, of course, Encore will handle typically the production of the funding deeds, and we look at those to see that the real estate owned by the client is being transferred into the trust, and that takes care of that. So the real estate, is then owned by the trust. But we also talk about the client's other assets, financial assets, life insurance, things with beneficiary designations. That needs to be done in such a manner that uh, it eventually it is either owned by the trust or it eventually gets to the trust by beneficiary designation. So we talk about that in our letter, about how to direct different types of assets to the trust, whether it's after the death of one spouse or after the death of both spouses, depending on the nature of the asset, so that ultimately everything gets into the trust and then can be handled by the dispositive provisions of the trust.
Yep, love that. The thoroughness and this of making sure funding is there. I want to ask you more about that as we go in the conversation. So once that then is your team uploads that review letter, and then that becomes available within our software for the advisor or client to then download as part of the document package. And so we turn all of that around within 10 business days, giving your team, John, time to review the documents and do your work. And so that's kind of the expectation that you can look for when you choose this option, that the documents will be returned in 10 days with that attorney letter. If there's the option that they choose to have a conversation, that gets set up with an email that gets sent out to book a calendar where Ross and Matthew attorney can talk with the client and do that 30-minute phone call. And that's all explained in our knowledge base. And so please go reference all the details there specifically to the state of Texas on how all that works. And so really it's all about really additional peace of mind that clients, many clients, when they understand this option's available, really appreciate that next level review. A lot of our advisors really appreciate, John, what you guys are doing there, that they have feel good about that. Some compliance departments too really see the value of getting that next level review from your team. And so that's where that really kind of fits into the process. You mentioned there, and I kind of wanted to go back to it. You've seen a lot of issues where trusts are in, documents are in place in a living trust, but it's not funded. And you've said you've done a lot of probate work. How have you seen that play out where trusts don't get funded? Because I speak to this, why it's so important. This is part of where advisors are able to help the from a beneficiary designation, from making sure the client is aware of all these decisions that go with funding the trust. However, where have you seen, issues with that when someone thought they were okay and they maybe realized they weren't because of that next level work?
Sure. Well, taking a step back, it's good that we're to this point to begin with,
Hmm.
because most people, they don't want to talk about estate planning at all, and it's just not a popular topic, and
Yeah.
they just kind of put their heads in the sands when that topic comes up. And then when they do get started, they tend to procrastinate and take a long time to get from the beginning to the end. So,
Mhm.
a program like this, that it kind of sets everything in order and sets everything in motion, that's really great to meet the client's needs and get to the finish line.
Yeah.
But part of getting to that finish line with respect to a trust is not just getting the trust done, but you've got to get the trust funded, because there has to be assets in the trust to be controlled by the trust. You may have a trust that says, upon my death, uh, my assets are going to go to my kids, but the house is sitting over here and your other assets are sitting over here and they're not in the trust. So the trust doesn't have any application because it doesn't have the assets that so that it's able to control those assets. So we will end up then with a trust that is empty and really has no application because it doesn't hold any assets. So part of this program and part of what we've always done in the past as part of our practice is to have a pour over will along with the trust document. And a pour over will is a will which simply says that the client leaves everything to the trust. Because even though you're going to go to through all the steps to fund the trust, to deed the property to the trust, to have your beneficiary designations lined up, sometimes you might forget something. Or sometimes you may acquire an asset at some point later and forget that that needs to go in the trust. So the pour over will is in place so that if you do have assets that you own personally, you can still probate a will to get those assets into the trust so that they can be controlled by the trust. But the idea of having the revocable living trust is to not have to go through the probate process. So that's why funding is very important, because even though you have the pour over will, you don't want to do that, because that's why you had the trust to begin with, is to avoid that probate process. So even though you have that as a safety net, you still want to make sure that everything gets funded so that the trust that you've gone to these great lengths to make, and it contains the dispositive provisions that you want, actually has some application. Now, if you didn't have a pour over will as a safety mechanism, then you've got a real problem, because now you've died intestate without a will and without a trust that has been funded, so you don't have anything. So then the law will dictate where your assets go in that situation, and it may not be where you want them to go. So very important to follow through with the funding and get everything to its completion, and then keep up with it going forward as you acquire additional assets to make sure they are either in the trust or directed to the trust.
And this is where I get excited about this, because this is a huge challenge for most people. And the work also of getting the documents in place is hard enough. And then, but to get people to focus on, okay, now what do we do once we've got these documents in place to make sure they're properly funded? And that's the benefit of leveraging a relationship with an advisor who's there for all of the aspects of someone's life, is at some level of the quarterback, taking a technology platform, and then with a review, first level review, you guys as a second level review, and the advisor participating in the funding, is I think we are making a big impact on being able to impact the experience to make sure it's done and done right. And so it's exciting for me to kind of think about there's someone there to facilitate this with the clients, and the funding part of it, as you're saying,
Yeah, and I think it's
is
important,
key.
an important role that the advisor plays in that as well, because not all assets should be immediately directed to the trust. As far as IRAs and 401ks and certain tax deferred
Yep.
assets, they need to stay at the
Sure.
husband-wife level
Yep.
before getting to the trust. And the financial advisor can certainly, assist with, making those types of determinations.
Yeah. Yeah, that's that's great. And those are, I think, some of what you even say sometimes within those review letters
Right.
as well, kind of depending on what you're seeing there. And so, yeah, how do you see that? And help us maybe understand a little bit more about Texas nuance. We have a lot of advisors around the country that may not be in Texas, but they have clients in Texas. And as we maybe a lot like me, advisors who might have had California clients, that there's no shortage of former Californians in the state of Texas. And those advisors might be looking for, who do I have as a resource in the state of Texas? But and what's unique about Texas compared to other states, and what applies in Texas specifically as we think about estate planning?
Yeah, I think it is at least somewhat unique with regard to being a community property state.
Okay.
So I think there's only 10 or 11 community property states in the US. So that makes us somewhat unique in that everything that is acquired during the marriage, no matter who worked, who didn't work, who made more money, who made less money, who stayed home with the kids, doesn't matter. Everything acquired during the marriage is owned half by the husband and half by the wife. The only exceptions to that are anything that either spouse owned prior to the marriage is their separate property. And then anything acquired by gift or inheritance during the marriage is that spouse's separate property. So there's a distinction as to the character of the property, whether it's community or separate, and what each spouse controls as part of his or her estate plan. For example, if the wife inherited property from her parents, that's hers and that's subject to her control. And so she may want to do something different with that than the more common thing of husband and wife give everything to each other and then it passes down to the kids. We might want to keep that property for the kids, for example, in that situation. So you've got different characterizations of property. The other nuance is blended families, and my kids, your kids, or our kids. That's also a very important consideration in how to pass property. And the rules, the laws of the state of Texas, as far as succession of property, if somebody passes away without a will, can be very surprising. So it's very important to have some estate plan in place, because if you die without a will, as I mentioned earlier, your property may go someplace by law that you may not intend it to go to. And let me give you an example of that. Let's say that husband and wife, they have been married for 50 years and they have accumulated all of their wealth during that marriage. And it's all community property. It was all during the marriage. Husband owns half, wife owns half. They have 3 children. They're all children of the marriage. Now, if the husband died in that scenario and he did not have a will, then everything would pass to the wife by law, but only because they had all the same children. But if we change our example and say that husband and wife had the 3 children, but husband had a child prior to that marriage that is not the wife's child, then the husband's half of community property does not pass to the wife, it passes to the kids. So now everything that the wife has and the husband had is now owned half by the wife and half by the children of the husband. Wow. So imagine that type of situation where maybe the wife doesn't even have a relationship with the older child, and now they're partners in these assets. So there's a lot of gotchas and a lot of uh-ohs in estate planning, depending on the family situation, the character of the assets, and that all just completely goes away. You can toss it all out the window if you have an estate plan in place. And that's why you got to do it, because you've earned what you have, and you have the right to control what you have. So you need to do that through these documents. And if you don't do it, you lose control and it goes where the law says it goes.
Yeah, isn't that the key term here is control?
Yes.
And if in the loss of there is no control without that. And this is a great point that advisors need to provide that good general legal information around, do you want control of what happens here? And so we've talked about kind of the funding side of this. One of the other things is maybe you could speak to as well, a role where advisors sometimes are engaged is bringing up an existing document that maybe was created 10, 15, 20 years ago and reviewing estate plans for keeping them up to date. Maybe give your insights on what you've seen or what issues can come from documents that may be there, because a lot of advisors will just check the box. You have one? Great. Okay, you got one. Moving on. But is it current? And are funding documents, funding, but then also keeping current? That's that third leg of proper estate planning. Share with us your insights there.
Sure, and I think it's a great idea to review any document that may already be in existence, because there's a number of things that may have changed over the years. For example, maybe you had provisions for your kids because they were younger at that time, but now they're older and you don't necessarily want nor need those same provisions. Maybe you had executors in place or trustees in place at that time, who would no longer be appropriate to serve in those roles, maybe because they've gotten older or they've passed away or you don't have as close of a relationship. Maybe your kids are to the point where you can put them in those roles now since they're older and more mature. Your asset situation may have changed. Tax laws change all the time. The estate tax thresholds change, and maybe some simple documents were good for you some years ago, but now you've accumulated some wealth over the years, and now maybe you have to do some estate tax planning to avoid estate taxes, or at least push them down the road a little bit. And so those are all the things that we're looking at. Are is the plan still the same? Are the people still the same? Do you need any extra protection or extra planning because your financial situation has changed?
Yeah, and those can create problems if they sometimes I don't know, your take on the out of date estate plan. It's better than no plan. But if it's out of date, it can create some issues as well, right?
It can, yes. Like I said, it could be out of date with respect to the law. If there's maybe the language that we like to put in the wills and trusts has evolved over the years, and now we have better language that maybe wasn't in those older documents. Your financial situation may require some more complex language in the documents. When we do documents, we always try to build in contingencies. Like, I appoint this person as trustee, but if this person can't do it, then I appoint person B and person C and so on. Or this is how I leave my estate. But if this person's no longer here, then that portion goes over here, and those types of contingencies. Maybe those older documents didn't have all those contingencies, or they have all played out, or something to that effect. It's always good to have your documents reviewed at least once every couple of years to make sure that they're still up to date. And especially after there's been some type of life event, somebody's passed away, there's been a divorce, something of that nature.
So you're saying, John, the will and trust maybe template you worked from in 1991 is a little different from the one in 2024?
I would say so, yes. I would say that the language has evolved over the years.
Hmm.
The courts have said over the years what's good language and what's
Yep.
not so good language, and we like
Yep.
to have all the good language in there. Uh, so that older language may not be appropriate for 2024.
Yeah, exactly.
And you want to have, whether it's a will or a trust, you want to have the best language in there that's most recognized by law. It's been interpreted many times. Third parties who may be looking at the trust document want to be able to see that language and see
Yeah.
that this is a good trust because it's got this up-to-date language in it. I don't have to worry about sending some archaic document to my legal department to see if I'm okay to honor it when I do something with these bank accounts or these policies. I see we have a good up-to-date document that uses all the generally accepted terminology. So it's always good to be current for sure.
Yeah. The the last piece to talk about here is where as you know, John, we recognize at Encore we're not a fit for all client situations. And there's the time and place we believe the attorney should absolutely be involved directly in creating the documents. We have our disqualifying questions that the advisors listening to this are aware of, that you're aware of as well. And we find advisors all over the country struggling with those clients who have there that are out of state, that they don't have they locally always generally have pretty good attorneys they've been partnering with, but they don't around the country. And so one of the things that we think is really important is building this network of firms like yours that can be available to advisors when they go have those plans that aren't a good fit for Encore, that have that level. Maybe it is that both couples have kids from previous marriages and some of the decisions there become more complex. Talk to us about that side of the estate planning team you've built, and especially also we know the estate tax exemption for us. If anybody's near that, they need irrevocable trust planning. that is where we want to have a partnership with you, that our advisors have a firm they can trust in Texas, and go to. Share with us a little bit about your team and maybe working in those kinds of cases that and where you've worked and the work you've done in the past.
Sure. Yeah, and there's several areas of that need particular attention. Well, one of course that we've been talking about is the estate tax.
Mhm.
And I always recommend to clients that they keep an eye on the estate tax because it's a high number right now. It's, $13.7
Mhm.
million dollars or something like that per
Mhm.
person. Spouses can combine their exemption, but that is due to be sunsetted at the end of 2025 and revert back to about $6 million dollars per person. So you're basically, cutting it in less than half at that time, unless Congress does something in the meantime. Um, Now, with the election, now being over and the Republicans having control, it's a pretty good bet that that number is going to stay pretty high, but we don't know that, and so we, have to keep watch on the estate tax and then react accordingly. If that number ever did come down, then more people are going to need tax planning. The other areas that require particular attention are special needs. Um, if you have a person in your life who receives SSI because they are incapacitated in some manner, then you don't want to give them assets outright through your estate plan because that could disqualify them from receiving government assistance. So there's a trust called a special needs trust that can be created for those beneficiaries so that they have some benefit to what you want to leave them or from what you want to leave them, but it doesn't disqualify them from government assistance. And the other area would be non-citizens and non-permanent legal residents. They have a much greater tax burden, while a U.S. citizen or a permanent legal resident would have the $13.5 million estate tax exemption. A non-citizen, non-permanent resident only has a $60,000 estate tax exemption this year. So they are almost always subject to estate taxes, and they need special planning, special trusts to try to at least defer that tax down the road. And that requires a special kind of trust. For that situation, we've got a special kind of trust for the special needs situation. And then we have our tax planning trusts as well, to try to either avoid or reduce estate taxes for high dollar estates.
Yeah.
So we have experience in all that over the years, and certainly would be able to talk to those clients and talk to them about what they need.
Great. And I think we have advisors that are uniquely appreciate the value of estate planning and making sure these things are done right. And so, and so my thought is also in how the advisor is there in parts of this role is they're looking at the financial plan and the impact on those pieces, and you're taking on if it's a state tax aspects of that. And the advisor aware of that process and kind of engaging with the client. I think this is a huge win, even when they work directly with you. And so we're thrilled to have you available to our advisors that I think are taking this very serious, and they have clients who you're a better fit than Encore. How would you want advisors to reach out or connect with you? What's the best way to do that? If they have those clients that aren't a fit, that they're not working through the Encore platform on the document review portion.
Yeah, and I'm happy to hear from them by phone call, email. We can certainly put the information out there.
Yep.
But I just want to say also that we have a lot of great relationships with financial advisors, with accountants, CPAs, and we have a lot of mutual clients, and we work together with them all the time over the years when they have a client that's in for accounting work or tax work or financial advising, and they start talking about estate planning, and then it comes to us, or we have a client that we're doing some wills for, and they might need they have just a bunch of cash sitting around. and they might need some financial planning. And so we have a lot of great relationships with financial planners and accountants. Have a lot of mutual clients over the years. So I think that's a great resource, and
Yeah.
happy to take that on
Yeah.
anytime.
Yep. Our knowledge base has all the contact information there too, for Ross and Matthews. So John, thank you so much for joining us on the podcast. We're grateful for the partnership with you, and how we can help really get more of these estate plans done and properly funded. It's an important thing for our world and to improve the experience along the way as well. So thank you everybody for tuning in to another edition of the Advisor's Guide to Estate Planning podcast. Appreciate the support. Remember, feel free to subscribe, leave a review, share with colleagues and friends. For any questions or feedback, feel free to email us at Encore at info@encoreestateplans.com, and have a great day.